those to parties in the case and had nothing to do with and not to parties of a case that's closed, which is related to that case, but to parties in the case. And I think he has mischaracterized what I've done. It's that simple. It all will come out
Justice Weaver,
as the more it comes out.
in the interest of openness, which point you've made several times today, would you be willing to share with the public exactly what the record shows in this case?
What case are you referring to, Justice?
I'm talking about the matter that was the
The
subject.
one that I disqualified myself in?
The matter
Yes.
that was the subject of the referral, yes. Would
I
you be
simply
willing to share that
disqualified
fully with the public?
myself because I had, and in fact, I'll just release my letter of disqualification, and then y'all can complain that I let out something in a case, because that's the little,
No, you're the respondent.
just a second.
You're free to do that.
And I will release to the public my letter of disqualification, and I'll tell them right now. It was simply that I met with an attorney who, unbeknownst to me, and maybe I should have known, after a case was closed, who had a question about the convoluted decision of this court in the case, and I did say what happened. The case was closed. Then it came to my attention that the AGC had acted with respect to this case, unbeknownst to me, because remember, all the stuff that the AGC is doing is secret from us. And so they dismissed the case. Then we got a motion for superintendent control of the AGC, at which point I then, and there was sealed files that said I had had the conversation with one of these attorneys. Well, the fact of the matter is I had, but it wasn't about that issue in the complaint. It was about the former case that might be related, but not as part of that case. So I decided, because after all, since 2003, I've been trying to get disqualification rules in writing at this court. And so we finally did, over the protest of my colleagues who are not happy with me. And we finally got them after the fourth colleague, or the majority of four, was unelected substantially. But in any case, so what I did was decide, and this is the rules, when you think there may be an appearance of impropriety because I had met with this person, that I would reveal it to the parties. So I sent them the letter. This is the terrible thing that I have done that Justice Young has talked about, because I revealed and that had to go to the parties in the case.
Justice
And there were
Weaver?
17 parties on one side, all attorneys, by the way.
Will you reveal
Just
the
a second.
papers?
Would you be willing to reveal it for the second
I
time?
said I'm going to release it to the press
Can
as soon as
we
this is over.
reveal the other side?
That's up to you.
Well, I'm asking for your permission.
No, I don't give you permission.
Yeah, we really are getting way
Now,
beyond.
what I'm saying is
way
I
beyond where this
disqualified
moves.
myself.
Well, you have it, they can
Okay.
ask you for it.
Okay,
We have
so
asked whether
I'm not
several...
giving your
at this
material
point,
out.
let's
You give your own
call the
material out.
question and
Well, that's quite open. That's quite an open response to the question that Justice Young and I have asked
Justice
several
Martin,
times.
this is not on point, okay? The question here before us is whether to adopt Justice Weaver's motion. I'm going to
Which is
take a
second,
roll call vote. Justice Hathaway?
Because AO-2006-8 was required to be documented by a recorded vote of this court, and it was not, I support Justice Weaver's.
Okay, Justice Markman? Yes or no?
Can't we embellish things like we've just heard here?
Well, I'd prefer yes or no here.
Okay, I'll
Well,
vote.
yes, you
I'll vote
support my
no.
motion.
Yes.
Okay,
That
no.
was not-
Justice Young?
No.
Justice Corrigan?
No.
Justice Weaver?
Yes.
Justice Kavanaugh?
No.
Justice Kelly votes no. The motion passes, the motion fails 5-2. Now, I have my own motion on this, and I'll explain why I'm bringing it. I and others on the court have taken this whole problem that you've just heard about very seriously. It's only just happened. It's very recent. And I have asked that we consider Justice Weaver's contention that AO 2006-08 was not ever valid. And as I look over her,
Excuse me, Justice, I have never said it wasn't ever valid. It was valid from December 6, 2006 to January 17, 2007, when we failed to retain
Okay.
or amend it.
okay, I stand corrected then.
Okay, thank you.
It appears to me that, number one, we have passed this administrative order, as with other administrative orders, following the rules we've used to pass court rules. And those who've been at this conference this morning have heard that we have, in passing court rules, always ratified or rejected an emergency order after public hearing, and that wasn't done in this case. Justice Hathaway has pointed to the specific provision that we've used in doing that. I think there's no issue with the fact that we never recorded a vote after the public hearing on Administrative Order 2006-08. Now, if that's then a fatal flaw, I'd like to see us correct it. And I say this because, number one, I take this matter very seriously. Number two, I believe that we need a rule of confidentiality. I believe that, to the best of my knowledge, all Supreme Courts in the country have it, either inherent or, implicit or explicit, and the U.S. Supreme Court has it. I think it's vital, it's essential for the court to be able to produce its business, to vote on cases in confidentiality,